Welcome to this special edition of Legal AF. I'm Karen Friedman Agnifilo, joined by my friend Matthew Seligman, been on the pod before. Matthew is an election scholar and has recently written a book called How to Steal a Presidential Election. Matthew, there's no one I'd rather have with me today than you to talk about this historic decision, this unanimous 9-0 decision, basically ruling that Colorado can't remove Donald Trump from the ballot. He not just Colorado, but the states can't take it upon themselves and create, quote, chaos by having different qualifications and different standards for people who can be on the ballot under the 14th Amendment insurrectionist clause. So, this is a historic decision for many reasons. It's a victory, a sweeping victory for Donald Trump. It's a 9-0 decision. But there's some very, very interesting things that this does do and doesn't do. And I'd love to hear your thoughts on really a deeper dive on what this means and why this isn't just a sweeping victory for Donald Trump. For example, they didn't rule that he wasn't an insurrectionist. So take it from here. Tell us what you see in this decision.
Well, thanks for having me on again. It's great to be here. As you say, this is a historic decision. It's also an expected decision. After the oral arguments, it was absolutely clear that at least 8 of the justices were going to say that states didn't have the power to do this. So it's expected. And really, the court watchers were looking at exactly how the court was going to reach that decision and what they were going to say about what happens next. So there are 3 things that really stick out to me about this opinion. The first is, as you say, it is unanimous. All 9 justices said that states do not have the power to bar people from the ballot for federal offices on the grounds that they were disqualified under Section 3 of the 14th Amendment. So the court was unanimous about that. And the second important thing, as you indicated, is that they said nothing at all about whether Donald Trump is in fact disqualified or not. They said nothing at all about whether he in fact engaged in insurrection in the days leading up to January 6th and on January 6th itself. So that issue is just completely wide open. And it's really important to keep in mind because Donald Trump has a history of claiming total vindication when in fact there was not total vindication. And so it's very important for everyone to understand this is not total vindication. This is kicking the can down the road. And so it says that no, down the road, states can't bar him from the ballot. And so that leads us to the third question. What happens next? And that's where all of the interesting issues are and all of the uncertainty remains. So the court says that Congress has to do something, but it's not 100% clear what that something is. There are a few things that we know would count. So if Congress passed a law that said Donald Trump engaged in insurrection and he is barred from the ballot, can't serve as president, that would be enough. Now, realistically, that's not going to happen, especially with Mike Johnson as Speaker of the House. So the question is whether anything else will be able to address this issue at all. And that's the question that we're going to have between now and Election Day, between Election Day and January 6th of 2025, and from January 6th of 2025 to January 20th of 2025.
And what do you mean, what else? In other words, what else could happen besides Congress, right? What are those options?
So there are, given the fact that it's unlikely that any new legislation is passed, what remains then is, okay, is there any existing legislation that could be used for this? And the court points to 2 possibilities. One is the Enforcement Act of 1870, which is now basically dead letter. And the other is the federal criminal insurrection statute, which has been on the books since the 1870s. And Jack Smith notably declined to prosecute, to charge Donald Trump under the.
I always thought that was weird, right? I always thought, I know why he didn't do it, I think, but I always thought for this reason, it was kind of the elephant in the room. It's like, it would be like not charging a rapist with rape, only charging them with kidnapping or assault, but not the gravamen of what they did.
Yeah, and the strategy, for your listeners is it's kind of like charging Al Capone with tax evasion. Why did that happen? It's because it was going to be easier to prove. And Department of Justice didn't want to, have a more complicated, more difficult case. That could, it seems quaint to think about this now, could make the case take longer. And so there are definitely concerns that drove that decision. But one thing to look at is whether this decision by the Supreme Court today prompts Jack Smith to revisit that decision. And he can amend the indictment and add a charge. And
but won't that just delay things even more?
It could. I'm sure it would. But that's one of the very few remaining possibilities to address this issue prior to the election. It may be the only way it could be addressed prior to the election.
Now, why do you think the Supreme Court was not persuaded that the Select Committee of Congress did find Donald Trump to have engaged in insurrection?
Well, they don't say one way or another anything about that. And what instead we can infer is the reason why that wasn't sufficient to count as congressional action disqualifying Donald Trump is because that wasn't a joint resolution that was passed by the House and the Senate. Open question whether Biden would need to sign it as well. And so it was one congressional committee. And you can sort of say that the entire House, because it was the committee acting on behalf of the House, had done that, but the Senate didn't. And the question wasn't really posed, okay, is he disqualified from office pursuant to what we're doing right now? So you might wonder whether Congress should have taken that kind of action when Democrats had control of the House, which they don't now.
So there was a unanimous decision here, but there were two concurrences, right? It kind of broke out along gender lines. It's almost like the women went off and then got into a little back and forth between each other. And interestingly, one of the women, Amy Coney Barrett, used the word strident, which is a uniquely gendered, nobody ever describes a man as strident. I don't know. I found that sort of somewhat interesting, but why don't you talk a little bit about these concurrences and why you think they did it and what they were saying and sort of the meaning behind them?
Sure. Now, both of the concurrences are really interesting, and it is interesting, as you note, that it did break down on gender lines, which is not necessarily something that you would expect in this case. Mm-hmm. And I think that might have to do. I mean, obviously, the three liberals are all women, and so that's part of the explanation. But it is really interesting that Justice Barrett wrote this very short, really, I thought. It's interesting, the thrust of her concurrence. It's a paragraph long, and it says basically, let's all take the temperature down a little bit. We had to decide this issue in the middle of a presidential election, and that's what we want to do is not provoke more division in America by what we say about this case. Now, it's not 100% clear whether she was talking to the majority or to the other concurring justices Kagan, Sotomayor, and Jackson, but it kind of seemed like the latter. So that brings us to what did Justices Kagan, Sotomayor, and Jackson say? Now, as you said at the top, and one of the most important things to take away from here is that they agree 100% that states do not have the power to remove Donald Trump from the ballot. So that top line conclusion is the same. Now, it's also true that, like the majority and like Justice Barrett, they do not say anything at all about whether Donald Trump did in fact engage in insurrection. So all 9 justices completely stayed away from that question. So what did they disagree with the majority about? What they disagreed with the majority about is they felt that the majority was too limiting in the way it talked about what Congress has to do from here. So the majority opinion pointed to, as I said before, the basically dead letter 1870 Enforcement Act, and then the federal.
What do you mean by dead letter? That's not a phrase that I think our viewers might be familiar with.
Yeah, so it's something that hasn't been used for a very, very long time, and it's not clear the extent to which it's operative anymore. So it's not really a viable legal option.
What is it?
So the Enforcement Act was something that was passed in the aftermath of, so it was 1870, right after 1868, and it was supposed to enforce it. And it's undergone a number of revisions since then. It hasn't been used for 100 years. And to my knowledge, it's not really something that could be used going forward. But now we may see it may be sort of resurrected, and people will start testing the extent to which it could be used. And then we have the federal criminal insurrection statute that we talked about before. Now, what the concurrences say is, well, why did you say that those were the only two things that could be done? All we really need to say is that states don't have the power to do this. There are a whole bunch of other possibilities at the federal level. And they mention a couple in particular. So they mention the possibility that somebody could use as a defense in a federal, for example, criminal case, saying, oh, the person who indicted me doesn't have the constitutional power to do that because they're not eligible to hold office. And so let's unpack what that would mean a little bit. So an argument that's been raised in Donald Trump's cases, criminal cases, is that Jack Smith's appointment as special counsel is unconstitutional. Now, the courts have rejected this completely. The argument is that, well, he has to be, the special counsel has to be appointed by the president because he's a principal officer under the Appointments Clause, et cetera, et cetera. Now, the courts have rejected that. And so Jack Smith's appointment is safe. But that's the kind of argument that the concurrence was gesturing to here. Let's say there's somebody who engaged in insurrection on January 6th, Madison Cawthorn or somebody like that. And he becomes a U.S. attorney. And he brings an indictment against somebody saying, charging them for anything. And then as a defense in that, the defendant says, you aren't eligible to hold office because you are disqualified under Section 3 of the 14th Amendment, Mr. Cawthorn. So court dismissed my case. And so that's the kind of federal action. This is a federal criminal case. That's the kind of federal action that the concurrence is saying, hey, majority, why are you cutting that off? That's a perfectly valid way for this to be adjudicated at a federal level. Now, one of the implications of that, though, is this case isn't about Madison Cawthorn as a hypothetical U.S. attorney. This is about Donald Trump as a potential future president. And so is the concurrence really saying that one of the ways that this could have been adjudicated is, sure, Donald Trump is inaugurated on January 20th, and then the first thing he does, whoever's affected by that, sues and says, you can't do that to me because you are not eligible to hold the office of the president.
Well, one of Trump's arguments was you can't disqualify me from running. Maybe this could come up later about holding office, not running for office, and so he made that argument, and so it sounds like the concurrences are saying, yeah, why are you taking that away?
Right, and what is that? There's no legal basis that the majority gives for taking that away. So it says that Congress has to act in this particular way, but it's a little bit vague about it, and it doesn't really give much rationale for specifying things the way it is. And actually, both Justice Barrett and the three liberal justices agree about this. They say, look, majority, you didn't have to say any of this stuff. All you had to say is that states don't have the power, and that decides the case. Why
do you think the majority did that? I mean, because obviously it's not like the first time the majority heard this argument was in the concurrences. Clearly, there must have been some back and forth between them, right? So why do you think they went that far?
It's tough to say because they don't give any rationale for it. But you can sort of look between the lines here and imagine what, for example, Chief Justice Roberts, sort of an old school conservative, who wants stability, what he wouldn't want. And so let's unpack that hypothetical of what would happen if somebody brought this ineligibility argument as a defense on January 21st of 2025. Well, let's say that person wins in court. That means that every single thing that Donald Trump, hypothetical future president, does is invalid legally. He had no power to do it because he's not really president. But he's sitting in the Oval Office and he's not impeached. Who is going to physically remove him from that office? Who is going to tell the military that they're not supposed to follow orders from him before? Is it his vice president, who I think we can be pretty certain wouldn't be Mike Pence? probably not somebody with the same sort of allegiance to the Constitution. So I can imagine that, the justices in the majority were concerned about that kind of chaos. But the problem with that is, okay, so tell us when and how this world historical question about whether Donald Trump is actually disqualified from office, when can it be decided? And there's, your listeners might be forgiven for wondering whether this is a shell game, where it's, okay, so the Supreme Court says, okay, we can't decide this issue over here. Oh, but that over there, that's not another, that you can't decide that issue over here. And then you might wonder, okay, so just tell us where and when this can be decided. And please make it a way where it's not just a completely rigged game from the start, where it's impossible to actually get the decision, the question decided. And, it may be that the Supreme Court ultimately ends up saying, look, the only way that this could possibly be done is through, bipartisan legislation, which means it's not going to be done. But at this point, we just want to know where this issue can be resolved. We're going to the right institution. The right institution to resolve these kinds of legal issues is the courts, and ultimately the Supreme Court. That was the problem that Democrats had with the way that Donald Trump and his allies tried to overturn the 2020 election. The courts had spoken, and Donald Trump said, well, I don't care what the courts think. I'm going to go and try to get Mike Pence to do something unconstitutional. That was a huge problem. Indeed, that was quite plausibly insurrection. And now Donald Trump's opponents are trying to get the courts to resolve this issue. And nobody has indicated that they wouldn't follow what the Supreme Court said if the Supreme Court rendered a decision that they didn't like. And so people are just begging the court to do the thing that we think the court is supposed to do, which is resolve these extremely complicated and politically contentious issues, legal issues, outside of the arena of politics. And the Supreme Court thus far has refused to do it.
Yeah, I mean, look, when Judge Luttig first came up with this, Donald Trump is disqualified under the 14th Amendment insurrection clause, my gut reaction that had to do with just judgment, not law analysis, not legal analysis, was no way, this can't happen. This just can't. It just can't be the case. This can't be the law. And so, frankly, I'm not surprised that this is, in addition to now having dived deep into the legal issues and then heard the argument. But at the end of the day, I'm not surprised this is the result, because it just would sow chaos, and it can't. Congress does need to act, right? Congress, I think, needs to make things clear so that you don't have this patchwork, I think is the word they used, of various decisions on whether or not he's an insurrection. It just never made any sense from a just logical standpoint. But so much of the rest of the decision to me was, let's take the temperature down. Okay, did you think of that when Dobbs, when you ruled Dobbs and outlawed, abortion, basically, essentially, practically, overruling Roe versus Wade and allowing, the crazy things that are happening all over the United States, and a patchwork of whether or not, frozen embryos outside of the uterus are human beings, and you can be charged with murder, essentially, for destroying them. So it's fascinating that they talk out of both sides of their mouth, and that they're willing to do certain things in certain areas when it suits them and not in others. But look, 9-0, that's a victory. That there's no way to look at that any other way, in my opinion, than just a victory. And that's what people will see. People will see that, Donald Trump was able to get a 9-0 decision from all 9 justices, despite the fact that there was nothing said about disqualification for federal office, and despite the fact that they didn't expressly overturn the arguments. They didn't expressly overturn the arguments in that other courts have found him an insurrectionist. So that's what people are going to see. He keeps winning. He keeps winning. In ways that just is so frustrating. The presidential immunity decision that now may jeopardize whether he even goes to trial federally before the election. And Mar-a-Lago, obviously, there. And then the Fani Willis crazy rabbit hole they've managed to muck up. He's doing it. He's doing exactly what he set out to do. And it's just a very bottom line, results oriented, zero sum game that he's playing and that the rest of the world is playing. So here we are on the day, March 4th, the day that he was supposed to start the trial in Tanya Chutkan's courtroom in Washington, D.C., and face the case of January 6th. It was supposed to start today, but instead of starting today, he gets a huge 9-0 victory in the Supreme Court. And I just find that ironic and disappointing. And I am so appreciative that you were able to jump on first thing and talk with me about this morning, Matthew. Thank you so much. And let's keep fighting.
Sounds good. Thanks for having me on.
All right. Take care.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.